how advertising works in the metaverse, powered with NFTs. And we've got, I guess Gianfranco is not here today, so it's going to be a fireside chat between Zach Lewis and Hannah Taylor.
Testing, testing. All right. Thank you, everyone, for joining us today. As you all know, if you paid a lot of attention the past year, most of the conversations surrounding the intersection of blockchain and the law have been around intellectual properties, securities, knowing your customer, and intellectual property. But some of the biggest areas for concern is actually in consumer protection and advertising law, so that's what we're going to talk to you about today. My name is Zach Lewis. I am an interactive entertainment and blockchain technology attorney at Frankfurt Kernet Klein & Sells, which is a media and entertainment law firm in New York and Los Angeles. I'm also a very proud NFT degen and collector, and I'm the founder of Blockchain Barristers, which is a global community of lawyers who are discussing and actively shaping the intersection of blockchain and the law. And with me, I have Hannah Taylor, who is a partner at Frankfurt Kernet. She runs our blockchain technology and our advertising, marketing, and public relations groups. She is an incredible thought leader in this space who's been working with some of the biggest brands in America for many, many years. And on a personal level, she's a fantastic mentor. We were supposed to have a third panelist, but because of a family emergency, he had to leave New York yesterday. So we're keeping Gianfranco and his family in our thoughts, but the show must go on. So, to start, I think it's important that we set some context because most people don't know that advertising as defined by the law is much broader than the way we think of advertising when we're talking about it colloquially. So advertising under the law is any speech or communication that's likely to influence the commercial decisions of consumers. It does not require a sales pitch. It does not require a buy now button. It does not require purchasing ad space. It can be your NFT roadmaps. It includes the content on your websites, including FAQs. It includes the communications that you and your teammates are having on Discord and Twitter. So again, it's important to understand that advertising, as the law sees it, is much broader than what we think of. And Hannah, why does that actually matter?
So thanks, Zach, particularly for your kind words. So one of the reasons that it matters, we heard throughout the day people talking about, is an NFT a security? And that's an interesting question, but even if we are outside of the securities realm, once we are merely communicating with consumers in an exchange where we might be influencing what they buy, we are regulated by an entirely different regulator, the Federal Trade Commission, and many of the state regulators that act as mini FTCs looking out, amongst various behaviors that all of us are doing and how we're communicating with consumers and how we're getting them to buy. Once the FTC sees something as a commercial speech transaction or something where you might be trying to influence someone's purchasing decision, a few key things happen under the law. The first is you're required to tell the truth. Now, when I say this at Thanksgiving with my family, they're like, that cannot be the law because I watch television and I watch what advertisers say to me all day, but actually there's a fair amount of regulatory attention based entirely on whether or not we are deceiving consumers or whether or not we are doing what's called omission, which basically means not telling people things that are very material to them that might influence their purchasing decision. So once you are in the commercial speech bucket, you have to immediately worry in a way that you don't if you're under the First Amendment putting out news content, putting out art, putting out other types of content about whether or not you're speaking truthfully. We also moved to a different section of the intellectual property laws. Once you are speaking commercially, New York Times can put Donald Trump on the cover of the New York Times. They don't need to go to Donald Trump and get a release from him because they're not speaking commercially. They're using their First Amendment protection to be newsworthy. Once you are engaging in a potential commercial transaction for consumers, you do need permission to use people's names, their identity, which can not only include someone's actual image, but maybe like a PFP that looks like somebody that's famous, and you would need written permission. So once we're in the commercial speech bucket, we have a whole different set of rules that we have to abide by when we're speaking in different ways.
And on top of the Federal Trade Commission, what other agencies are paying attention to this space in terms of enforcement?
Yeah, so it's a really good question. One of the weird things about the advertising business And the way that it's regulated is that we have the Federal Trade Commission and we have the state attorneys general. But we also have a very unusual thing called the National Advertising Division, which is a self-regulatory body that was created in the 70s when the advertising business was out of control and everyone was committing false advertising. Regulators came to the business and said, you got to regulate yourself or else we're going to come down hard. So the business itself created a self-regulatory forum that's basically like a consumer watchdog that watches all consumer activity and figures out whether or not people are engaging in false advertising. They're also very interested in the blockchain space because they too want to make a splash and be relevant. So you could also hear from the National Advertising Division. Plus, consumers can bring private rights of action. Each of the 50 states has a law that allows consumers to sue you to the extent that you don't deliver on utility that you promised or promote using influencers who aren't appropriately disclosing key facts. So that's another tricky thing about the advertising business is that consumers can also act as mini enforcement actors.
So now that we know some of the rules for playing in the sandbox, pun very much intended, how do these issues actually come up in Web3?
So I find the Web3 space particularly exciting because I think, much like you said at the beginning of the talk, people think, oh, advertising in Web3, that's going to be when I buy a television commercial space in the Super Bowl and I'm going to market my marketplace. To me, it's actually much more complex than that. In 2015, the FTC actually issued this piece of guidance called the Native Advertising Guidance. If you haven't read it, it's really important to read for our space in particular because it is, it's not law, but it is the sort of thinking from the Federal Trade Commission on what could be considered deceptive or potentially misleading to consumers when you're advertising to them in a context where they might not realize they're being advertised to. So it came up a lot in when social media first got really popular because like BuzzFeed would put out a list of articles and some of them would actually be like sponsored content. You wouldn't be able to tell, like is this a magazine article or is it an ad? That guidance though is going to come up for sure in our world because people will enter metaverse spaces that are sponsored by brands or someone will pay an influencer to walk into a space and to the extent that people don't understand that the interaction that they're having is being paid for, that is unquestionably a violation of existing law. So I do think we're going to see the regulators on our side of the table also try to make a splash and become relevant.
So as someone who's been working with Web2 brands for a long time and has been working with Web3 brands for about over a year now, is there a major difference when you're working with a Web2 brand versus a Web3 brand or any brand on a Web2 versus a Web3 endeavor in the advertising world?
So it's an interesting question. We often say at our firm that we help major brands come into Web3 and we help Web3 native clients figure out what the rules of our space are. So we sort of approach it from both angles. I think the main difference that I found is that when you represent, a Coke, a Nike, which is sort of like our core business, they understand that advertising and the legal rules that are going to attach to that are going to be fundamental to their business because they understand that a huge piece of what they're going to do is market to consumers. And I found that in this space, people are very concerned about IP attached to their commercial rights or the license that they're giving, and people are very concerned about securities issues. But for some reason, the consumer protection or advertising side, which is equally relevant and important for you to realize, is part of the sort of panoply of things you need to think about, are sort of not at the forefront of people's minds. So it's part of the reason why I wanted to do this panel is to educate the community about the fact that this is maybe not something you're focused on, but is definitely something that regulators in our side of the business are focused on.
And so if I'm promoting a project as an influencer or an employee or just a fan of the NFT collection and their team, what are my responsibilities and what kind of concerns do I have depending on what role I'm taking there?
Yeah, so it's a great question. We often represent not the influencer, right? We represent the marketplace, the crypto company, the brand that's doing something. And often what happens is that a huge piece of their strategy for getting the word out is to, give Jimmy Fallon their NFT and hope he tweets about it, or hire a bunch of influencers in the space who they know have amazing Twitter followings to chat about their project. And all of that is legal and fine. The issue is that there are well-traveled and highly relevant enforcement actions from the Federal Trade Commission and rules about how to do that. And regulators in our space are particularly excited right now by the fact that our community has not tapped into what the influencer business went through however many years ago, which is the need to disclose when you have a material connection when you're posting. Like many of you probably know about hashtag ad or have seen a hashtag ad in social media posts. The reason for that is because it's the law where if you have some relationship to a project and you're out there talking about it, you have to disclose if that relationship might be material to consumers who are looking at the post. And Zach smartly said that can come up in the influencer side, but it can also come up in the employee side. If you work for a super amazing project or your wife does, you're also required to explain your material connection there. So all these rules are things that the Federal Trade Commission has spent years suing Warner Brothers, suing Lord & Taylor, suing Cole Haan, like in the influencer side of things, and there's no question that they're going to be interested in these same types of projects and seeing that the same types of issues travel into Web3 as well.
Speaking of issues in Web3, I think everyone in this room is aware of the Frosty's rug pull, right? The question, so what we know from that enforcement action from the Department of Justice is that outright fraud, promising things without any intent to actually deliver them, can land you in prison. But what happens if someone just goes too far promoting their project without that kind of, malicious intent from the get-go?
Yeah, so it's such an important question because false advertising is a strict liability regime. Sorry for those who aren't lawyers. Basically meaning your intent doesn't necessarily matter. So what's important to realize is that while you may have not committed fraud if you didn't have an intent to deceive, to the extent that consumers were misled by something that you told them, like, buy this NFT and with it you will get a meet and greet with X band, and then shoot, the deal with the band fell through. Sorry, community, we can't actually make that happen. That's actually false advertising, right? So to the extent that we are putting roadmaps out, to the extent that we're tweeting about what we think the project will offer, and any of that could be announced to the community in a way that could be material to them in order to purchase, and then we don't end up delivering, those are the types of risks that are, as Zach mentioned, less than core fraud, but definitely solidly false advertising. And just an important thing to remember before you go out, we're not just here to scare you. I mean, the best way to handle that is to not say anything that might be material to someone until you know the facts. So you can what we call tease all you want. You could be like, awesome things to come, stay tuned. It's not that you can't promote, it's just that you don't want to specifically offer something that might cause someone to press the purchase button before you're sure that you can deliver on precisely what it is that you're telling them you're going to give.
And for those in the audience who are thinking about launching an NFT project or already have, how can they make sure that the consumers are actually aware of the material terms that they're obligated to disclose under the law?
Yeah, so, over the course of these few days, we've heard people with incredible technical ideas of how to solve this problem, right? I think this is for lawyers, whoever decides to do this in a smart way, and we have many brilliant clients who are trying to solve this as well. Whoever can figure out a way to allow the terms that are relevant to a consumer to sort of attach to the asset themselves, to be on chain, to be manageable in some sort of coherent way will be, wildly successful because it's a huge hole in the industry. I think now what's challenging is that you're required when you're advertising a project before someone actually presses purchase, to give people all the material information that they might need in order to buy, right? And a lot of the times that, when you think about like the Bored Ape license, all of that is just icing on the cake, right? It's just like an extra commercial license. It's utility, it's promise, and that's great. The thing that is harder is when you're trying to restrict, like not give someone a commercial license, tell them they can't use your art in any way, tell them that you retain the copyright, or that the utility will only be for the primary purchaser and nobody who buys it on the secondary market will be able to get, the meet and greet with the band. Anything that would be really material for someone to understand before they purchase, the law says has to be served to them in what's called a clear and conspicuous way. And people are supposed to, in a perfect world, read that in a way that they really can see and opt into it. And of course, we all have situations where we use products or we interact with various consumer flows that aren't that perfect, but in our space, I think in particular, the terms are often very disjointed from the sale page, right? I can buy an NFT where a company does an incredible job at serving me the terms, and then someone takes it off that marketplace, puts it on a different marketplace, I lose the terms, I don't see them, I don't know what I'm buying. So I think we're gonna see particularly if there's some like really expensive NFT with some very material restriction to it, some sort of consumer lawsuit or angst about the fact that they weren't told what they needed to be told before purchase.
So there are a lot of discussions on intellectual property law and NFTs, and they usually focus on copyright and trademark infringement. But how does intellectual property law intersect with advertising in Web3?
Yeah, so I mentioned at the beginning that one of the core things that's important from deciding whether or not something is or is not commercial speech, one of the reasons that that's such a fundamental question for any lawyer when they're trying to figure out, like, what is this content that's in front of me, is because once you deem it commercial speech, again, remember the Donald Trump example, you're going to need permissions that you might not otherwise need. That's how Saturday Night Live can mock Hillary Clinton and doesn't need to go to her people ahead of time and say, like, you know, may we please use Hillary on the show. They have a First Amendment right as artistic speech to parody her. When you're selling something, parody doesn't really exist, and a lot of other exceptions, like fair use exceptions, also don't exist. So permission is usually required, and it's particularly important not just for the art that's associated with your drops, but also for your promotional content. There was a case where Lil Yachty sued recently for a drop that was, you know, there was sort of a deal in the works between the NFT company and Lil Yachty that ended up falling through. And they didn't take down the promotional tweets that they'd put out to the communities talking about how they were going to drop a Lil Yachty NFT, and he sued for violation of his right of publicity, saying, you're using me in a promotional context without my written permission. I didn't sign this deal. And so I think we need to remember that we're in a new world in a lot of ways, but we're also not in a new world in a lot of ways. People will still try to assert long-standing rights, and once you're using them commercially or for promotional purposes, they have certain rights that they don't necessarily have if you're using them for artistic or editorial purposes.
And I think you touched on this earlier, but I want to circle back because one of the major points about Web3 is that it does combine creative and commercial endeavors. And I think that it happens to the point where people aren't necessarily aware that they're being advertised to. So what legal issues arise as a result of that tension?
So it's sort of like a two-part question, because I think the first thing is, and this trips a lot of people up, is that just because you are selling something doesn't necessarily make it automatically commercial speech. Like, if you are paying attention, your first question to me might be, well, I don't understand, like, someone can sell a movie, and that's clearly artistic speech, but they're still selling the movie. Are you telling me that that automatically becomes advertising just because it's being sold? And the answer is no. As Zach mentioned really importantly, but I want to repeat it, fundamentally, it's really about speech that's meant to influence a sale. Not something where money is involved, but something where you are actively trying to get someone to buy. So you can imagine a situation where you are selling First Amendment protected work that's associated with your non-fungible token, and that would not be cleared as commercial speech. But then when you go on Twitter and you have 100 tweets promoting your project, the tweets would be. So it's very important to think about what types of speech apply to different contexts, and because you're in different sort of areas of the First Amendment, different rules are going to apply. And that's why, you know, maybe you and your lawyers thought very hard about whether or not you had a good fair use or First Amendment protected reason that you could use a particular piece of art or a celebrity in your actual art associated with your NFT, and you might not be thinking about that when you then go promote it on Twitter, and once it's in an ad, you might lose that First Amendment protection. So that's the first thing. The second thing is that there was a recent, not a case, but another sort of thing that happens in the advertising business a lot, which doesn't usually happen in other contexts, is that we have a fair amount of consumer watchdogs who are very active, one of whom is called the Truth in Advertising Organization. And what they do is they're a very well-funded private consumer watchdog organization that sort of trolls the market and figures out if there are things that people are doing in, you know, in the marketplace that might be considered deceptive to consumers, and they're very interested in Web3. And they spent the last year investigating Roblox, and they just published to the Federal Trade Commission a very long, very detailed, clearly well thought out argument about how the Roblox experience actually violates every consumer protection and advertising law that's out there, because people don't understand when a store has been sponsored by a brand, or people don't understand that when LeBron's avatar walks into a certain room that he's been paid to be there. People don't understand when they are deciding what rooms to enter, pre-click, that they might be offered things or spoken to or interacted with in a way where they're actually being sold to. And one of the key things that happened in Web 2 was that we were required to label every space. If this was an advertisement, or this was a branded space, as paid advertisement or sponsored by X brand. And both the Federal Trade Commission and the Truth in Advertising Organization are very concerned with how that's going to work in Web 3 and in these new metaverse spaces where it's much more fluid. I mean, it's not like LeBron's avatar. I mean, I guess he could wear a shirt that says #ad, on his avatar, but someone smarter than I will have to figure out exactly how that's going to work. And because we don't have the comment section on an Instagram post, or a lot of the ways that we sort of thought about it in Web 2, this is going to be the future of what I do.
Well, on that note, I want to save time for maybe one or two questions, but what is your prediction for how this landscape is going to change from a legal perspective over the next 1, 2, 5 years?
I think the big thing will be that we will get some regulatory attention from regulators on my side of the spectrum, and people will start to notice that many of the things that have covered the influencer business in Web 2, or that Fortnite has dealt with, or any of the sort of Web 2 spaces have thought about, are going to come into the forefront in Web 3 as well. And I think maybe people will finally realize that the consumer protection and advertising side is sort of just as fundamental to thinking through a project and thinking through how to promote it as it is to worry about taxes or speak to your securities lawyer, because I do think it's coming.
Definitely. We have about a minute left. If anyone wants to answer or ask us a question, we're happy to answer it.
Can you hear her?
I think they just want an example of an active case.
So the Roblox thing is the closest thing that we have to an ongoing investigation. I mean, there are many existing lawsuits where people have been sued for failure to disclose material terms. The Roblox case is the first really big one in the Web3 context. And so I think once we see whether or not, well, one thing I also should mention, and that I didn't, is that two things are happening on the Federal Trade Commission's docket in the next few months. The first is an update to what's called the endorsement guidelines, which is the Federal Trade Commission's interpretation of endorsements and testimonials in commercial speech. And in the next few months, they're going to be updating that. And one of the main things that they've alerted the community that they're going to be focused on in that is influencers and endorsers in Web3. The other thing that that they specifically mentioned is that they're going to update what's called the .com disclosure guidelines, which is basically their guidance on how to legally disclose what you need to disclose to consumers in digital media. And one of the main things that they came out with there was to talk about how they think that current disclosures in Web3 are highly inadequate. And so I think that they will get what they normally do after they issue guidance, is they then bring 3 or 4 major enforcement actions that comes from the guidance to show, we mean business, this is guidance, but you're doing it wrong, you're doing it wrong, you're doing it wrong. And so I think in the next few months, out of those updates, we'll see some real regulatory cases. Yeah.
We have only 10 seconds, Carl.
10 seconds. What is the quick advice you can give to the consumer or the collector as to do's and don'ts when they talk about projects and products?
Okay, excellent question. So Carlos asked, what can you guys do? The first thing is say what your connection is. So let's say you're a collector, you're being paid by so-and-so, or you got given NFTs to do 5 tweets. Just say super excited to be partnering with X project. You could put #ad, but I'm excited to be partnering with is equally fine, or, so excited to be involved with this project. Anything that makes it clear to consumers. And the key thing there is to say it in every post. If you say it once, you can't assume that people, like next time you tweet, people have seen the previous post. And crazily enough, it has to be in the first 2 lines of any social media post. It cannot be like lower than the more button or at the last hashtag or anything. So that's another key fact.
Thank you guys for listening and for joining us today.
Thank you so much.
Thank you.